Good afternoon everyone, my name is Kwan Yushen, student ID 03681117. Today I'll be analysing a legal dispute between State Aramaica's suspension and State Botuna's defences regarding the Vienna Convention on the Law of Treaties 1969 (VCLT). We will also explore how principles such as jus cogens, material breach and pacta sunt servanda intersect with environmental protection in international law. Let's begin with the legal principles for the VCLT relevant to this scenario. Firstly, Article 60 addresses the termination or suspension of the operation of a treaty as a consequence of its breach. Paragraph 1 specifies that a material breach of a bilateral treaty by one of the parties entitles the other to invoke the breach as ground for terminating the treaty or suspending its operation in whole or in part. Furthermore, paragraph 3b defines a material breach as violating a key provision essential to accomplishing the treaty or purpose. This was illustrated in Hungary and Slovakia ICJ 1997, the ICJ holding that the breach was not sufficiently serious to justify termination under Article 60. Secondly, the term rebus extensivus aligns with Article 62 of the VCLT, which addresses the fundamental change of circumstances. Paragraph 1 states that a fundamental change of circumstances which has occurred with regard to those existing at the time of the conclusion of a treaty and which was not foreseen by the parties may not be invoked as a ground for terminating or withdrawing from the treaty unless subparagraph A, the existence of those circumstances constituted an essential basis of the concern of the parties to be bound by the treaty, and subparagraph B, the effect of the change is radically to transform the extent of obligations still to be performed under the treaty. However, paragraph 2b prevents evocation of this doctrine if the fundamental change resulted from the invoking party's own breach. Paragraph 3 allows suspension, not just termination, if the requirements are met. In the Barcelona Traction 1979 case, the ICJ rejected Belgium's claim under Article 62, ruling that economic changes did not justify ending the treaty. Thirdly, under Article 53, treaties conflicting with a peremptory norm of general international law as known as jus cogens. A treaty is void if at the time of its conclusion, it conflicts with a peremptory norm of general international law. For the purposes of the present convention, a peremptory norm of general international law is a norm accepted and recognized by the international community of states as a whole as a norm from which no derogation is permitted and which can be modified only by the subsequent norm of general international law having the same character. Additionally, Article 64 demonstrates that if a new peremptory norm of general international law emerges, any existing treaty which is in conflict with that norm becomes void and terminates. In Pub Mills case, the ICJ stressed the importance of environmental protection over shared waters but did not recognize water rights or environmental duties as jus cogens norms. Lastly, the principle of pacta sunt servanda is outlined under Article 26, stating that every treaty in force is binding upon the parties to it and must be performed by them in good faith. In the Namibia Advisory Opinion 1971, the ICJ affirmed that treaties must be honoured in good faith, reinforcing the pacta sunt servanda principle. The first issue concerns State Aramaica's right to unilaterally suspend the treaty under Article 60, paragraph 1 and 3b of the VCLT, alleging that State Botuna's repeated failure to comply with environmental safeguards critical treaty obligation constitute a material breach. In Hungary case, treaty termination notice was deemed premature as the material breach occurred later. Similarly, State Aramaica must prove State Botuna's environmental violations like river pollution were clearly established before suspension. Besides, in the case of oil palms ICJ 2003, the court rejected claims when violation did not undermine the treaty's purpose. State Aramaica must prove State Botuna's serious breach and comply with Article 65's procedural requirements, including notification and negotiation to justify suspension. The second issue focuses on State Botuna's defences. State Botuna denies breaching the treaty invoking rebus extensivus under Article 62, paragraph 1a and b, claiming climate change fundamentally altered its environmental obligations. To prevail under paragraph 1a, State Botuna must establish that the original environmental conditions such as river flow and ecosystem stability were a critical factor in its agreement to the treaty. Under paragraph 1b, it must show climate change radically transformed its duty beyond mere inconvenience. However, under paragraph 2b, State Aramaica might argue the climate-related damage stems partly from State Botuna's own failure to uphold environmental safeguards, thereby disqualifying State Botuna's from invoking Article 62 since it's contributed to the change. Alternatively, State Botuna might seek a temporary suspension under paragraph 3, but this requires meeting paragraph 1 criteria of fundamental unforeseeable change. The Fisheries Jurisdiction Case 1972 supports this interpretation, ruling that a change of circumstances justifying termination must lead to a radical transformation of remaining obligations, a threshold island failed to meet with its claim. Likewise, Hungary's 5 argument for termination, including a fundamental change based on political conditions and environmental advancement, were rejected because the court found this did not significantly alter the existing obligations. As a result, State Botuna's claim that climate change has made the treaty's environmental safeguards irrelevant. Although climate change is a pressing global issue, its application under Article 62 is limited. Given the restrictive interpretation of this doctrine in both cases, it is probable that a court would find that climate change has fundamentally altered the dam-related obligation, especially since such environmental shifts are increasingly foreseeable today. The third issue considers whether environmental obligation can evolve into just cogence norms, thereby overriding treaty provisions. In this scenario, State Botuna asserts that recent United Nations General Assembly resolution has recognized access to clean water as a just cogence norm, arguing that the dam's project water diversion violates this peremptory norm, thus rendering the treaty void under Article 53. While access to clean water is increasingly regarded as a fundamental human right, it has not yet achieved universal recognition as a just cogence norm within binding international law. A UNGA resolution to it may indicate emerging norms, lacks legal binding force and does not itself establish just cogence status. To qualify as a just cogence norm, a principle must be universally accepted, non-derogable, and possess superior normative force, meaning no exceptions are permitted. To date, international courts such as the International Court of Justice and the International Law Commission have not classified the right to water as a just cogence norm. For instance, in the case of Democratic Republic of the Congo and Uganda 2005, the ICJ highlighted the importance of access to water during armed conflict but stopped short of elevating it to just cogence status. Similarly, in Belgium and Senegal 2012, the ICJ affirmed that the prohibition of torture has achieved just cogence status, being universally recognized and non-derogable. However, Article 53 applies exclusively when a treaty conflicts with a just cogence norm at the time of its conclusion. Since the treaty between State Arabica and State Botuna was signed a decade ago, prior to alleged emergence of this peremptory norm, Article 64 of the VCLT is more likely to apply here. Nevertheless, this argument hinges on demonstrating that the right to the water has attained just cogence status, a status that has not yet been definitively recognized under international law. In short, State Botuna and State Arabica are bound to perform the treaty in good faith under Article 26 of the VCLT unless there are justified exceptions such as material breach under Article 60, Paragraph 1 and 3, Subparagraph B, or a conflict with just cogence norms under Article 53 and 64. To resolve this dispute, I propose 5 recommendations. To begin with, states must modernize bilateral treaties to incorporate current climate science, ensuring environmental provisions remain relevant and enforceable amid evolving ecological challenges. In the scenario, the treaty between State Arabica and State Botuna lack flexibility to adapt to current climate conditions. For example, the Mekong River Commission is actively updating its water sharing framework to include climate adoption measures, exemplifying proactive treaty modernization to address changing environmental realities and ensure sustainable resource management. Besides that, under Article 33, Section 1 of the UN Charter, a joint fact-finding commission should be established to ensure Arabica's suspension of the treaty is based on objective evidence. The commission, made up of neutral experts, would examine environmental data such as water quality reports to determine whether Botuna committed any breaches. A relevant example is the UN Commission for India and Pakistan in 1948, which investigated the Kashmir conflict and helped mediate a ceasefire, showing how fact-finding supports peaceful dispute resolution. Furthermore, the status of environmental just cogence norm need to be clarified. State Botuna's argument that the dam treaty violates a just cogence norm highlights the growing importance of environmental rights in international law. Although the right to the water is not yet formally recognized as just cogence, UNGA Resolution 76/300/2022 affirms the human right to a clean, healthy, and sustainable environment. This supports the need for clearer legal status. Scholars like Mamaloha Cervantes argue such rights meet just cogence criteria, urging international bodies like the ICJ and ILC to clarify this area. Additionally, treaties should incorporate phased dispute resolution processes to avoid unilateral actions and encourage collaborations. State America ought to have followed Article 65 procedures before suspending the treaty unilaterally. An ideal treaty would feature a structured approach, neutral environmental fact-finding, technical mediation, and if needed, legal arbitration or ICJ referral. The Prespa Agreement 2018 between Greece and North Macedonia, resolved through UN-led mediation, exemplifies the effectiveness of staged, peaceful diplomatic efforts. Finally, strengthening judicial oversight through international courts such as the ICJ is essential to resolving complex treaty conflicts. By granting tribunals clearer authority to interpret and balance principles like pacta sunt servanda, just cogence, and material breach, states can avoid unilateralism and uphold the rule of law. In the Hungary case, the ICJ balanced environmental concerns with treaty obligations, affirming treaty bindingness while recognizing evolving environmental norms. Villalpando 2010 stresses that judicial harmonization preserve legal coherence as emerging rights like environmental protection approach just cogence status. In conclusion, Aramika's suspension may be justified if it proved a material breach, while Botuna's defenses of changed circumstances and just cogence are too weak under current international law. This case shows the growing tension between binding treaty obligations and urgent environmental needs. As international law evolves, environmental protection might gain just cogence status, but for now, pacta sunt servanda prevails. Thank you.